All right. Court is calling the matter of the people of the state of Michigan versus Brian Keely, case 24-60116FY. Counsel, I'll have you place your appearances on the record. I understand we're having a hybrid proceeding this afternoon, and so from the AG's office.
Yes, good afternoon, Your Honor. Oronde Patterson, representing the people. First name spelled O-R-O-N-D-E. Last name is Patterson. P number is 57211.
Welcome, counsel. And then my understanding is that the defense is joining us on Zoom today. I have a number of people joining me on Zoom today. And so could I have the defense please turn on their camera and maybe give me a wave so I can see in all of these boxes who I am.
I'm trying to judge Mark Curtis on behalf of Mr. Keely, 59274. It says that my video, the host can stop my video.
And Your Honor, Erica Tusar on behalf of the people, P56831. Thank you.
I'm sorry, your last name once more?
Tusar, T as in Tom, U, S as in Sam, A, R as in Robert.
Thank you. All right. Well, Attorney Curtis, I know that we did have some permissions set so that we had limited interruptions. My Zoom gatekeeper is in charge of that. Let's see if she's able to fix that for me. Well,
There we go.
there we go. Fantastic. All right, fantastic. Now, before we really get started, I would like to acknowledge, as I did at our arraignment proceeding, that I know the majority of observers here today are here for this specific matter. It is an emotional matter. These are serious allegations, and so I'm simply asking that the decorum of the court be respected. And therefore, if you find yourself overwhelmed by the emotions of the proceeding, I'd ask you to please excuse yourself voluntarily. You may do so at any time in a calm manner. If you are unable to exit in a calm manner, then court security can assist you and escort you as well. This is the date and time set for a probable cause conference in this matter, and the parties stipulated that the proceeding may be held by Zoom, but clearly we are doing this as a hybrid matter today. And we're well equipped to handle a hybrid matter, but if anybody at any time cannot hear me or cannot see me or cannot observe the proceeding, please let me know. And that way we can ensure that the public is able to observe these proceedings and that every party is able to hear and see the other side. We want to remedy any technical situation that we may have so that everyone can easily observe whether they are here in person or by Zoom. The next thing I would like to address is that after this court was closed last Friday, I received notice of removal filed by Attorney Curtis, asserting that federal court is the proper venue for this matter. And then approximately 3 hours ago, I received a notice from the Clerk of the United States District Court, Southern Division of the Western, that the matter has been assigned to a judge in that court and removed. It is a notice. Obviously, the federal court supersedes my authority, but the notice alleges deficiencies in the proofs of service required to the adverse party. It's further not an express order stating that the case is removed to federal jurisdiction. As I read the statute, there is no order of summary remand, and therefore the U.S. District Court shall hold an evidentiary hearing on the matter, and this court is not prevented from proceeding. Now, it may be most prudent to adjourn proceedings until there is a little more clarity, especially given the fact that most of this has happened outside of this court's operating hours. But I'd like to hear from the parties as to their position and whether or not there is any agreement to stay proceedings in this court at this time. I guess I will start with the Attorney General. What is your position?
Judge, there is no agreement to stay the proceedings. The people are objecting to the case being removed to the federal court. As the court has indicated, there is no court order stating that this court does not have jurisdiction to continue with the case. I understand that defense counsel has filed a notice. I understand that the clerk in federal court has placed the case on the docket of a judge there. But until then, there still is no court order stating that this court has lost jurisdiction. That particular hearing would have to occur. As everyone knows, all courts speak through orders. And so a notice filed with the federal court and the clerk placing it on the docket does not give instruction to all of the parties involved that a case has been removed. And so we are of the position that this court should continue to move forward with the case until and unless otherwise notified through some court order that the case has been removed to federal court. Now, that being said, I would concede that an evidentiary hearing is probably going to occur. Our office is in the process of preparing a response to this particular issue. Our office is familiar with this particular issue and that we've dealt with this in other parts of the state, this same exact claim. So we're familiar with it. We will file a response to be heard in federal court. But it does not change that we believe that this court should still proceed as if we're going forward unless told. Now, I say that to say we have a preliminary hearing date set for August 12th. I would ask that that date stay on track. And then if the court, federal court gives an order stating that this case has lost jurisdiction, then that takes care of it. If the federal court states that the case should be heard here, then we have a preliminary hearing date of August 12th that we can proceed on. I would like to keep that date because as the court is aware, we have lots of attorneys involved with this case. It is very difficult to sometimes get future court dates. And so I don't want to cancel a date just to come back and say, we're now before you, Judge, and we have to start all over to get a new date. And so we would just ask that the August 12th date stay in place. And we just proceed from there and we find out what the federal court says as it relates to the proper venue for this case.
Thank you, Attorney Patterson. Attorney Curtis, what is your position?
Your Honor, Attorney Patterson is correct. Under 28 U.S.C. 1455, until the federal court puts down an actual order removing it to federal court, the court is allowed to proceed, but is not allowed to enter any judgments of conviction or anything of that nature at that point in time. I'm sure the court's well aware of that statute. In looking at the timelines of everything that's been filed in the services, I expect this matter will probably be resolved before the August 12th preliminary examination. In regards to their objection filing and the court's speed in the federal trying to get this resolved, being well aware that we do have a preliminary examination set for August 12th. If the court is not willing to just stay the proceedings forward and there isn't an agreement to do so, then I would ask that we leave the prelim on for August 12th. As we've said, there's lots of attorneys. We went through a lot to find that date to begin with. So I would hate to take it off the court's calendar and then find out that we need to put it back on and find another date. But I do intend if we do get to the August 12th date and there's going to be a prelim, and at this point in time, I don't see any reason why we wouldn't go forward with that, minus the fact that it's been removed the federal.
All right. Thank you. Well, it sounds like everybody is aware and agrees that the statute indicates we can proceed short of entering a conviction, which this court was unlikely to do anyway. And so it seems appropriate to leave the matter on for preliminary examination let me ask Attorney Patterson, is there anything else that needs to go on the record today in terms of a probable cause conference? Or would you request this matter be adjourned to an additional probable cause conference date to be held in advance of that preliminary examination?
I'm not aware of anything that we need to do additionally in terms of the preliminary hearing. I have not talked to Mr. Curtis about that. And so if he is of the opinion that we may need another PCC date before August 12th, I would not disagree with that.
All right, Mr. Curtis?
Your Honor, I did just get, the state police went through extraordinary efforts to give me the discovery last Saturday. And so we're combing through that. It looks like I do have everything. The AG was very cooperative in making sure that I got that taken care of. At this point, I don't see any reason for us to have a PCC. I have Ms. Tucson, Ms. Patterson, and I have had good communication. If there is something we need to work out between that date and now, I'm sure we'll be able to work it out without the need for court intervention prior to that.
All right, well, it sounds to me as though I have two very competent and well-versed attorneys in this matter who could resolve any issues that came up prior to the preliminary examination date. As a housekeeping matter, Mr. Curtis, I see that you are with your client there. I recognize him. Is there another attorney in the room appearing on the record or someone whose appearance should be placed on the record? Because I do see 3 individuals in the room.
No, Your Honor.
All right. Thank you. Well, then I think that we are all in agreement and this court will order this matter shall proceed to the August 12th date for preliminary examination that will be held in person. I will entertain no stipulations or motions to appear by Zoom, and I will see everyone back on that date. Anything further, Mr. Patterson?
No, Your Honor.
Anything further, Mr. Curtis?
No, Your Honor. Thank you.
Thank you. We are adjourned.
Thank you.